We have another sighting of Vanzan, the shell company used by Blake Lively and Ryan Reynolds allegedly to obtain the text messages between Justin Baldoni and the other Wayfarer parties that was then used in Blake Lively's initial complaint. Vanzan was used to file a sham lawsuit so they could then subpoena Stephanie Jones, who put up no fight and willfully handed over all of Jennifer Abel's data and text messages. They filed the lawsuit against John Doe's even though they knew they were going after the Wayfarer parties, and they did that to make sure that the Wayfarer parties didn't have their chance to quash the subpoena. Vanzan is now refusing to designate a witness that would be prepared to testify about its relationship with Stephanie Jones and JonesWorks. The Wayfarer parties are moving to compel them to do so, and Vanzan has a deposition set for September 30th, which is now just 4 days away. The Wayfarer parties write, as set forth herein, Vanzan is attempting to curtail its testimony to omit information the court has already declared as relevant. Ms. Abel's counterclaims allege that in August 2024, just prior to her scheduled departure from JonesWorks, the Jones parties seized her cell phone, accessed the contents, and downloaded them. The counterclaims further allege that Stephanie Jones disclosed at least some of Ms. Abel's private communications to the Lively parties no later than August 21st, continued to access Ms. Abel's private texts thereafter, and at some point, transmitted Ms. Abel's stolen communications to Ms. Lively, her husband, Ryan Reynolds, and Leslie Sloan, Ms. Lively's publicist, to harm Ms. Abel. Ms. Abel also alleges that Ms. Lively conspired with the Jones parties to obtain Ms. Abel's stolen data under the guise of legal process. On September 27th, Ms. Lively used her company Vanzan to file a lawsuit in the New York State Supreme Court against Doe defendants. The complaint in the Vanzan lawsuit alleges that the Doe defendants, the identities of whom are unknown to Vanzan, breached unspecified obligations via unspecified oral promises and/or unspecified written agreements. Days after the Vanzan lawsuit was commenced, Vanzan issued a subpoena therein to the Jones parties, demanding the production of documents pertaining to the film It Ends With Us, Miss Lively, Mr. Reynolds, and sexual harassment and retaliation in connection with the production of the film, none of which are even remotely referred to in the complaint filed in the Vanzan lawsuit. So they knew exactly who and what they were looking for, and they filed a lawsuit basically representing that they didn't. Also, Vanzan has nothing to do with Justin Baldoni or the Wayfarer parties. They have never engaged in anything, any sort of contract, or anything like that, so the whole thing was a complete sham. The Jones parties then handed over Ms. Abel's communications to Vanzan. Subsequently, the Vanzan lawsuit was discontinued in December 2024. The same month, Ms. Lively included those communications in her pleadings. In late June 2025, Ms. Abel filed a motion to compel Vanzan to produce certain documents in response to a subpoena. The court properly determined that communications between Vanzan and/or its counsel and the Jones parties and/or their counsel concerning the Vanzan lawsuit are relevant. Okay, so that's kind of the background. Now we're getting into what the problem is now. The Wayfarer party's deposition subpoena commands Vanzan to produce a witness who can testify about enumerated topics, including the ownership and management of Vanzan, Vanzan's communication with the Jones parties, the subpoena issued in the Vanzan lawsuit, communications with Miss Lively related to that subpoena, and Vanzan's search for relevant documents. Now, of course, they don't want to participate in this because Vanzan is a broom closet owned by Ryan Reynolds and Blake Lively. So what are they going to do? Who's going to be a representative? So who was a representative for the company during that time? It would have to be Ryan or Blake, most likely. I don't know if anybody else was ever even really involved with the company. The company doesn't appear to have done anything in recent history. To my recollection, they, imported some furniture once? And now all of a sudden we're meant to think that they, in good faith, filed a lawsuit against the Wayfarer parties? Vanzan? Nah. Nonetheless, Vanzan is refusing to provide a witness who can testify at a deposition about such communications and the related topics. According to its written objections, Vanzan will only provide information for each of the topics starting from on or about the filing date of the Vanzan lawsuit, which is September 27th, 2024. Subject to that unreasonable limitation, Vanzan stated that it would designate a witness reasonably prepared to testify about non-privileged information. Stated differently, Vanzan only agrees to produce a witness to testify about what happened after the Vanzan lawsuit was commenced, but not before it was filed. Even though the communications between Vanzan and the Jones parties, or their respective representatives, concerning the contents of Jen Abel's electronic data seized by the Jones parties and subsequently delivered to Blake Lively through Vanzan, is highly relevant to Miss Abel's counterclaims against the Jones parties, and even though such communications surely occurred before the Vanzan lawsuit was filed on September 27th, Vanzan is refusing to designate a witness prepared to testify about the foregoing. Vanzan argues that the information sought is obtainable from other sources. However, as the court stated in its memorandum and order, there is no per se rule that party sources must be exhausted before documents are subpoenaed from third parties. Putting aside that no other witness has testified about most of the topics, even if such cumulative testimony existed, the Wayfarer parties are entitled to test what witnesses to the same events have to say, and whether they contradict or corroborate each other. There is no undue burden imposed upon Vanzan. The corporation has known for months, and certainly since June 2025, when Ms. Abel moved to compel its compliance with the document subpoena, that it was in possession of information material and relevant to the claims and defenses herein. Furthermore, given the allegations and the counterclaims, the relevant period is not expansive. The Wayfarer parties agreed to limit the relevant time period to July 1st, 2024 through December 31st, 2024. The subpoena was initially issued on September 9th, 2025, and noticed the deposition for September 29th, which they adjusted, I guess, to the 30th, a period of 20 days for compliance, which is more than the 14 days the courts in this circuit have found to be presumptively reasonable. Therefore, the Wayfarer parties respectfully request that the court issue an order compelling Vanzan to designate a witness prepared to testify at deposition about the full extent of the relationship between Vanzan and the Jones parties, including the period before the Vanzan lawsuit was filed. In the event the court grants this application after Vanzan's deposition commences, the Wayfarer parties respectfully request that the court direct Vanzan to designate an appropriate witness to appear for a deposition consistent with the court's ruling concerning the topics during the first 2 weeks of October 2025. So, of course, these guys are going to object to everything because they know they're fucked. There was also a declaration by Kevin Fritz, the attorney. He writes, the deposition of Vanzan's representative, who has not yet been identified by Vanzan, is scheduled for September 30th. According to a biennial statement, the CEO of Vanzan is Ryan Reynolds. True excerpts from the transcript of the deposition of Blake Lively, conducted on July 31, are attached as Exhibit B. And of course, that's sealed, so we can't see that. A true copy of the subpoena issued by Vanzan to Stephanie Jones and Jones Works in the Vanzan lawsuit is attached as Exhibit D. And that is also, unfortunately, sealed. We've never seen that before. I know there was a whole thing, like everybody's looking for this subpoena, and then, Katie Joy and the Daily Mail kind of almost at the same time, but I know Katie Joy broke the story, had found the Vanzan lawsuit and put that together, that was the one that was used for the subpoena. According to the docket from the Vanzan lawsuit, a true copy of which is attached as Exhibit F, Vanzan did not file a request for judicial intervention, and no judge was assigned to the case. So here they're talking about the topics for the deposition. It's Lively's direct or indirect ownership interest in you, and you being Vanzan. Ownership interest in you. Your managerial structure. Good luck with that one. The parties' claims, allegations, defenses, and counterclaims in this action. The parties' claims, allegations, defenses, and counterclaims in the action Lively versus Wayfarer Studios. Your relationship and communications with Jones Works, and the issuance of and communications relating to the subpoena. Your claims and allegations in Vanzan versus Does 1 through 10. Your communications with Lively related to the subpoena. Your document collection, document search, and document production in this action. So here's where it gets really interesting too. These guys will do like anything to avoid this. On September 22nd, I met and conferred telephonically with Vanzan's counsel about its objections to the subpoena, including the topics. Vanzan's counsel claimed that the testimony sought could be obtained from a party. When I asked Vanzan's counsel to specify which party, Vanzan's attorney stated his understanding was that Blake Lively testified about the topics. In response, I asked Vanzan's counsel if they possess a copy of Miss Lively's deposition transcript, which has been designated confidential under the protective order. Vanzan's other attorney on the call answered, "We're not answering that," or similar words to that effect. Miss Lively did not testify about Vanzan except for one sentence. Even though the communications between Vanzan and the Jones parties, or their respective representatives, concerning the contents of Jen Abel's electronic data seized by the Jones parties and subsequently delivered to Blake Lively through Vanzan, is highly relevant to Miss Abel's counterclaims against the Jones parties, and even though such communications surely occurred before the Vanzan lawsuit was filed on September 27th, Vanzan has refused to designate a witness prepared to testify about the foregoing. Upon receiving the objections, so Vanzan obviously objected to everything, they don't want to answer any of that shit, the Wayfarer parties agreed via email to narrow Topic 4 to Jen Abel's counterclaims in this action and defenses thereto, and B, narrow Topic 5 to Blake Lively's allegation in paragraph 10 of her Second Amended complaint that she obtained the communications cited in her pleading in connection with a lawful subpoena. Furthermore, and with respect to Vanzan's relevancy-based objection, the Wayfarer parties reminded Vanzan that in its order dated July 7th, the court already determined that discovery from Vanzan was relevant to Jen Abel's counterclaims against the Jones parties. Given that the Vanzan deposition is scheduled for September 30th, merely a few days from now, the Wayfarer parties asked Vanzan to withdraw its objections to the topics by noon on September 25th. Vanzan has failed to do so. And in the emails, you can see they said to Justin's counsel, in the meantime, confirming we are planning on having a deponent testify on Tuesday. But they never named the deponent. And as I was recording this, remember, this was filed just last night. I see that Vanzan has already responded and objected to this shit. And I want to go over that too, but I'm going to have to start work in just a little bit. So I'll have to be doing that afterwards and when I get a break. And I'll let you guys know when that is. So thanks, everybody. Appreciate you watching. And I'll see you all soon.